Okay, City of Lansing versus Christopher Bradford, 25-01493, 25L2943-953 and 951. Appearances, please.
Patrick Wood on behalf of the City of Lansing, Your Honor.
Jacob Riley on behalf of Mr. Bradford.
Okay, who's present on Zoom? Today is the date and the time, and actually, Mr. Riley, you can let me know who your clients are on the record from now on.
Yes, sir.
Okay, let's see, today's the date and the time scheduled for a pretrial. I have a driving while license is suspended, a driving unregistered, and then there's a no insurance explanation hearing. Were you all able to resolve this?
Mr. Bradford is looking into what he needs to do to get his license restored. That's the main, I guess, obstacle to resolving this. My request is adjournment for at least 1 month so that we can follow some.
City has no objection to this being the first setting on this matter, Your Honor. Given the chance. Any license.
How long were you requesting, Mr. Riley?
At least 4 weeks, Your Honor, if possible.
August 26th at 8:30. August 26th at 8:30. Do you have any questions for the court today, Mr. Bradford?
I'm sorry, that's that date, August. Your Honor,
August 26th at 8:30.
okay. No, I don't have,
Did someone just admit someone in the courtroom?
No.
Oh, whoever's making that background noise. Okay, August 26th at 8:30. Did you have a question?
no, I don't, Your Honor.
Okay, any additional matters for the record?
Nothing from the city, Your Honor.
No, Your Honor.
You're all set for today, sir.
Thank you much.
You're welcome. City of Lansing versus Jordan Dotson, 25-01583. Appearance, please.
Patrick Wood on behalf of the City of Lansing, Your Honor.
Good morning or good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Dotson. I don't believe I've seen him today.
Okay, you've not had recent communication.
Left a voicemail for him, but that was around 4:45 yesterday.
What's your bench warrant?
Your Honor.
Okay, City of Lansing versus Cornelio Granado, 25-01406. Appearance, please.
Patrick Wood on behalf of the City of Lansing, Your Honor.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Granado, who is joining us via Zoom.
Your Honor, Mr. Granado, through counsel, has provided the city with proof of valid license, so the city moves to
Dismiss this matter.
No objection.
Motion to dismiss is granted. You're all set, Mr. Granado.
Thank you, ma'am.
You're welcome. City of Lansing versus Tyler Jones, 25L2942-992, 991, and 993. Appearance, please.
Patrick Wood on behalf of the City of Lansing, Your Honor.
He declined. Well, defender, is he present? On Zoom. Yeah, well, my court officer is supposed to explain this to me. Mr. Jones is
Mr.
present.
Jones, let's see it.
Where?
He's on Zoom.
Thank you. Mr. Jones, are you present?
Yes, ma'am.
Okay, today was the date and the time that was scheduled for a pre-trial. He met with the city attorney.
I believe so. Your
Were
Honor.
you notified that he was present and without counsel?
Not without counsel.
I have to call the case again later. On the, someone can go meet with them.
Mr. Wendell can meet with him.
He's gonna log in. Okay. So, someone from the city attorney's office is going to log in to meet with you.
Okay, thank you.
City of Lansing versus Aaron Skates, 25-01554. Appearance, please.
Patrick Wood on behalf of the City of Lansing, Your Honor.
You are Aaron Skates? Okay, today was the date that was scheduled for hearing. I have a hinder and obstruct the polls, pretrial and a furnishing false information. Did you all discuss this matter and how do you want to proceed?
Your Honor, if I may, Mr. Waddell did speak with Mr. Skates before we were on the record here today, and Mr. Skates indicated that he had submitted some documents to the court. And we did not receive any documents from.
There's been no motions filed with the court. There are some documents in the file, but that's not a properly filed motion according to the Michigan court rules, so the court does not have jurisdiction to review those.
Yeah, at this point, there was no offer made. We were giving him the opportunity to present us with some sort of documentation, but we have no motion.
Okay, they're not offering a reduction in the charge. You have the right to proceed to a trial. You have the right to jury trial. I think you declined court-appointed counsel and said you would retain an attorney. Is that accurate?
I was talking to one, but it's not really in my means to acquire the attorney.
Okay, so would you like to maintain your not guilty plea and proceed to trial, sir?
I don't consent to anything here. I can't. My constitutional rights were violated. So I am on the record. My status is a Moorish American national. I am not a Black person. I am not a United States citizen. So that's why I claim my nationality as a Moorish.
You don't have to be a United States citizen to be charged with a crime in the United States. And if I were you, I wouldn't go around here in open court live stream declaring that I'm not a United States citizen facing criminal action with the current federal administration. That was not in your best interest. I wouldn't do
I
that.
can't claim my national status on the record.
Yeah, okay, that's fine, but you are making a declaration that you're not a citizen. And we have an administration that is making efforts to make sure people who are not citizens who are facing criminal actions are deported.
So when I'm claiming my national status on the record, it's for this land here.
I recognize that. This land here is known as the United States of America. This court sits in the city of Lansing, Ingham County, state of Michigan.
United States is a federal
Okay.
corporation though.
Okay,
So when I claim,
Wonderful.
I'm not.
if you want to maintain, if you want to
claiming-
stand mute, you have the right to do that. You have the right to plead guilty or plead not guilty. I recognize that you're asserting yourself as a sovereign citizen.
No, not sovereign citizen.
What do you
Such
say?
a sovereign. Don't, it's confused, it's a misnomer to say sovereign citizen.
What, you're asserting yourself as what?
Just sovereign on the land.
Okay.
of American indigenous to the
Okay.
land.
I'm happy to hear that you're sovereign and indigenous to the land. The court will continue your not guilty plea. This matter will continue to trial, okay?
Can I get some type of documentation?
We're gonna give you the notice to appear for a jury trial. September 2nd at 8:15. September 2nd at 8:15 in person at the court, okay?
Okay. And
You need to wear a shirt that has sleeves.
I just came to work, so.
I recognize that, but I'm talking about for your jury trial. You're gonna need to be appropriately dressed, okay?
This isn't.
It is not. And I'm advising you of this on the record so that you know to come appropriately dressed for your trial. Okay? Thank you. Do you have any questions for the court at this time? Any additional matters for the record?
Nothing from the city, Your Honor.
Thank you. We'll get your notice to appear. You're all set.
Let's get that in the mail or?
No, we're gonna get to you right now.
Okay.
So meeting with Mr. Jones. Let's see, City of Lansing versus DeMarco Washington, 25-01535. Appearance, please.
Patrick Wood on behalf of the city of Lansing.
We did that one this morning. Oh, we did it. He appeared earlier today? Yeah. Okay, sounds good. City of Lansing versus Taiwo Adeli, 24-02434. Appearance, please.
Patrick Wood on behalf of the city of Lansing, Your Honor.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Adele, who is standing to my right.
Okay, and today was the date scheduled for hearing. This is a pretrial for operating a cabaret 2 a.m. to 7 a.m. Well, able to resolve this.
Not as of today, Your Honor. There was some ongoing conversation between myself and Mr. Waddell from a while back and Mr. Wood as of today. I think there's some inquiries being made at the city attorney's office. We'd like to allow time for that. If the court would grant an adjournment of about 3 to 4 weeks to see where we can land on that.
That is accurate. Your Honor. We're trying to sort some things out in our office to see what we can do.
August 26th at 10:30. August 26th at 10:30. Do you have any questions for the court today? Sir?
Actually, Your Honor, if I may, part of my following thing was going to be a bond modification request. Mr. Adele has an emergency medical emergency that he is going to be requesting permission to travel for. And the August 26th date is within the timeline that we're going to be requesting permission to travel within.
It's a family emergency?
That's correct, Your Honor. His father, I believe, and it is going to be requested to travel to Lagos, Nigeria between August 10th and September 10th to be present with his family for that.
There's a family emergency, it's July. There's a family emergency with his father and he's not leaving for over a month?
If I'm understanding correctly, there is a medical procedure happening during that time that
Okay,
they've asked him to be
got
present
it.
for.
Got it. So not necessarily an emergency, but there's gonna be a family.
Perhaps serious.
Got it, okay. And he already has his travel arrangements?
Yes, he's going to be traveling between August 10th and September 10th. He will be in Lagos, Nigeria.
September 23rd at 9:30. September 23rd at 9:30. Do you have any questions for the court? Any additional matters for the record?
Nothing from the city, Your Honor.
Just, Your Honor, when he returns, would you like him to confirm with me and I?
Absolutely.
Court?
I vaguely recognize you. Was it the Nigerian restaurant downtown?
Yes.
This is the subject restaurant. He's a business owner here. I'm sure he's coming back. Any additional matters for the record?
Nothing further. Thank you.
You're all.
Yes.
All kinds of things. We got civil in there too. Yeah. Okay, are we ready on Mr. Jones?
Yes.
Okay, back on the record in the matter of the city of Lansing versus Tyler Jones. Mr. Jones met with the city attorney. How are we proceeding on these?
Thank you, Your Honor. Patrick, on behalf of the city, Mr. Waddell did meet with him. He has indicated that he is sending some proof of his licensure over to the city. We've not got it at this moment. If we could adjourn just to get that documentation, treat that as a first setting with
Saying
the.
he has a valid license, is that what you're
Yes.
saying? It's not showing up on his driving record?
No, he said he just did it today.
Oh, okay. August 26th at 9:30. August 26th at 9:30 is your new court date, okay?
Okay.
Do you have any questions for the court at this time?
I don't.
What is the offer?
Need to distance.
For all of the charges or just that?
And yeah, responsibility to the remaining of his fee.
Okay. Okay, and he would accept responsibility to the others.
Specific.
August 26th. You're free to go, Mr. Jones, unless you have questions for the court.
I don't. Thank you very much.
Thank you. City of Lansing versus Shannon Augenschein, 18-06466 and 18L2397812. Appearance, please.
Patrick Wood on behalf of the city of Lansing, Your Honor.
Jacob Riley on behalf of Ms. Augenschein, who's
Not present.
sorry, I did not have to contact you. so-
Probably because this case has been pending for 7 years and they were given another PR box. After failing to appear 3 times. I'll issue a bench warrant. City of Lansing versus Teresa Cheeks, 21-03289. Appearance, please.
Patrick Wood on behalf of the city of Lansing, Your Honor.
Jacob Brown, on behalf of Ms. Cheeks, who is present to my right in the courtroom.
Okay, Ms. Cheeks is scheduled today for no insurance under insurance code pre-trial. Was there an offer on this or was it resolved?
It has been resolved, Your Honor. Defendant has shown proper documentation to support us dismissing this being the first. Dismiss.
Motion to dismiss is granted. You're all set. City of Lansing versus Michelle Craig, 24-02917, 24L2903901. Appearance, please.
Patrick Wood on behalf of the city of Lansing, Your Honor.
I have an attorney.
That's Mr. Akeem Johnson.
Two.
Akeem Johnson is the attorney in this file, so it's a substitution. Double checking myself.
Yeah, I'm looking at the note because this is the one he intended to do a competency on, and I'm reading the magistrate's note.
Correct, that was my note.
Of course, there was another PR bond after three failure to appears. City of Lansing versus Alejandro Martinez. This is 24-02697. Appearance, please. Oh, this is an arraignment. What's your name?
Martinez.
Excuse me?
Alejandro Martinez.
Okay, Mr. Martinez, I do have here a request in summons for probation violation. It states here that you committed the following technical probation violations. So you failed to refrain from alcohol for EverHealth on June 11, 2025, that you were positive for alcohol, yielding a result of 1,322.746 milligrams per milliliter ETG and an ETS 554.864. So you have the right to have a contested hearing, the right to be represented by counsel at that hearing, and if you're found to be in violation of your probation can be revoked. You could be sentenced to a term of jail time, or it could be extended, and other oversight or programming can be ordered. Do you understand that? You want to request an attorney to represent you for the violation hearing? We'll make sure that you meet with someone from the public defender's office before you leave here today. And this matter will be set for a hearing August 5th at 1:15. August 5th at 1:15 in person at the court, okay? You'll get your notice to appear. Is he gonna meet with you, Ms. Sutter?
Yes.
Okay, you'll meet with her after you get your notice to appear, okay? Thank you. Same to you. Ms. Johnson's taking a nap. She's gonna go into the waiting room.
I've asked the Samsung person several times what their name is. Exactly right.
What's your name? Unmute your device, whoever's on the Samsung. Not you, ma'am. The lady with the white sweater, what's your name?
Pamela Payne. I'm with Preservation Management.
Preservation Management. What's your case
Correct.
number?
2502762 LT.
Okay, that's Manor-Born. You're with Manor-Born?
Correct.
Thank you. You can rename her, please. City of Lansing versus Lakeisha Tyson, 24-01862, appearance, please.
Patrick Abud on behalf of the city of Lansing.
Afternoon, Jack Rucker on behalf of Ms. Tyson, who is approaching council table now.
Okay, thank you. Today was the date set for a hearing. This was for a determination on the defense motion for directed verdict as to count one. The court is in receipt of both the the prosecution and the defense's motion for support and in opposition of the directed verdict. I've reviewed both. Did you want to make any further record?
Yes, Your Honor. I just want to respond to some of the points raised in the City of Lansing's brief. There's really, I think, two issues, one significantly stronger than the other, as presented by the city in this matter. The issue of timeliness versus the issue of whether or not the burden was met sufficiently by the evidence that was presented. So as to the timeliness issue, Your Honor, the case that was cited in support of the proposition that you only have one limited window to make that directed verdict was ironically under the Parker case, not People versus Parker, but Parker versus Associates Discount Board. If the sections of that case cited by the city of Lansing, Your Honor, is somewhat detached from its surrounding context, and I believe that is too important to not be considered. I'm going to read the entire quote as opposed to just the truncated section. The entire quote that the city is relying on says that given that the defendant was obliged to establish his affirmative defense, and then this is where the city quotes, directing a verdict in his favor at the close of his proofs would be like directing a verdict for the plaintiff at the close of his proofs. That antecedent section of given that the defendant was obliged to establish his affirmative defense makes it clear that the court in Parker versus Associates Discount Court had a situation where both parties were carrying a burden. In this instance, as this was a criminal misdemeanor matter and not a civil matter, Ms. Tyson had no burden, and the burden entirely rested on the prosecution. As a result, I don't believe that that is applicable, and it can be distinguished clearly. With other than that case, they cite no other case law that supports the proposition that there's only one shot at it. MCR 2.516, I believe, is more expansive than they're letting on in terms of what is allowed and when the timing is. I think it's more of a beginning point cutoff, not a later point cutoff, saying you can't bring your directed verdict motion before this point, not that you only have one bite at that apple. And Your Honor, in looking at the enabling statute, as it were, the MCR 6.001, there's a section in there, and I apologize, I'm pull it up really quickly, and that would be section D that says civil rules applicable, and it lists off a series of situations where the civil rules would be applicable over the criminal rules. And it says the provisions of the rules of civil procedure apply to cases governed by this chapter, except, and I'm going to point the court down to 3, when a statute or court rule provides a like or different procedure. And I think given that we were specifically working under criminal law, I believe that it's close enough that we should use the procedure outlined under statute that we cite, the rule that we cited, that is a little bit more clear. And then finally, just as a more of a not tangential, but more of an overview argument, denying the ability to bring that motion at the time that we were in trial and kind of where that trial had ended. As the court knows, we straddled the end of the day when it came time for us to bring that motion. We ended up bringing it the next morning, and if we had brought it at that time, the jurors who had spent all day in this heat box would have likely had to stay even later, and I think that would have probably been even worse outcome in terms of making the jurors further upset.
Very considerate of you on behalf of the jurors.
Well, Your Honor, I could tell the jurors were suffering by 6 o'clock.
I could too. That's why we adjourned the second day. One juror had his tongue out his mouth, so it was blazing hot in there.
So with that in mind, Your Honor, I believe that would be elevating procedure over substance. This is an insufficiency argument, and on appeal, it would not necessarily require a preservation issue. It would be something that would be immediately reviewable de novo on appeal. So it kind of obliviates that issue of timing. And then as for our arguments under Parker, Your Honor, I'm happy to add additional argument to that unless the court's satisfied with the briefs that I have submitted on that.
Thank you. Mr. Peter.
Yes, Your Honor. Thank you. Few points. I mean, we do believe that this is procedurally improper. The court rules are black and white. They lay out which criminal court rules apply to misdemeanor cases. And the one that the defense relies upon is intentionally left out. I didn't draft those court rules. I just
Did it?
interpreted. I wish I did.
You're in a boot. I thought you guys.
No, we don't draft anything on that.
Okay.
And it's pretty clear at the end of your opponent's proofs. And while we don't disagree that, civil rules apply to a criminal case, it's what our rules demand.
But let me stop you there. If I take your argument to be true, and for the record, I agree with the city on this, that the rule that applies here is 2.516, but timing, it says a party may move, not shall, not must, but may. That does that indicate to you that it's a cutoff time or a beginning time?
Well, Your Honor, I wouldn't argue that it's necessarily either. I think it's open interpretation, but I do believe, and that goes to the Parker v. Associate Discounts case, where then we should be afforded our chance to rebut that.
To rebut what?
Their presumption by moving at the close of their proofs, if you want to call it that. That's what they're.
To his argument, that what you cited in Parker was where both parties had a burden of proof. That's not what we have here. There was no affirmative defenses that the defense was trying to prove. So if they had done what you said they should have done, which is make their motion at the close of your proofs, what would you be able to do to rebut at that time?
At that time, I'm not entitled to.
Right.
If it's at the end of my proofs. Am I following this correctly?
That's my question. That's
Yes,
my
at that time, I presented
So
my.
because they then presented some evidence, now you think that you now have, and then make a motion now, you still get a chance to rebut? Because in the federal rules, you can make the motion at any time, essentially.
I believe that.
That does not
the
grant you
felony
an
is as well.
opportunity to now rebut,
Sure. I do believe that we have case law that avails ourselves to. have-
not what you cited. That I agree with Mr.
Respectfully,
Rucker that the case is not on par to what the issues are here. If we're talking about, essentially in that portion of the ruling, the court is talking about there being a burden that the defense needed to prove. And so not exactly the same as what we have here. The other argument you were going to make was what?
A few things. I still think timing is still an issue here. It wasn't at the end of my proof. It wasn't at the end of his proof. It wasn't during closing arguments or after closing arguments. You had read final composite jury instructions. And if it wasn't for it being a hot box at 6 p.m., they would have been in favor. And I think it's a little buyer's remorse or whatever nomenclature you would like to use that they brought it the next day. Possibly that if your YouTube stream wasn't up and wasn't available for view, that might not have been. I don't know. That's speculation, pure. Second, I would like to address if the felony rule somehow doesn't, the criminal procedure on the directed verdict. Timing is also an issue because it's not just what the people have presented. It's all of the evidence up until the time that the motion is brought.
I agree.
And I think on that point, we had the defendant on the stand testify that, I believe she testified that she didn't think the knife was over 3 inches. We had officers testify that it was about 6 inches, and we saw a video. That is creating a fact question as for the jury, not for the court. So further. And with that, in deciding it, I don't think, regardless of it's the civil or the criminal rule, it's the evidence in the light most favorable to the non-moving part. We know what the verdict was returned, and I think that's further evidence that a reasonable person could come to a conclusion based on something. And if I may address the Parker case.
Yes.
Briefly.
Okay.
Parker case, that was charged under a felony statute. Let's be clear. The only evidence in that case to the size was an eyewitness saying it was hand size.
Because I can hear what the eyewitness saying what again?
The knife was hand size, quote unquote.
And the judge in that case ruled that was not sufficient because her hands or whoever's hands are not part of that. As
And hand
opposed,
size is pretty relative, isn't it? Like whose hands, you know?
yeah, and I think that is a deviation from what we have in our case, where we have an officer saying 6 inches, we have the picture of the knife. I think
We didn't have a picture, did we?
via
The body cam.
via the body,
Got it.
yes. And I think that draws a big difference there. Plus, once again, the conflict and then weighing credibility of both the prosecution and the defense, asserting her intoxication levels at that point to, recall the size at that point. Which is why we believe that if it doesn't be denied for procedural reasons, it should have been a question left for the jury to decide.
Brief rebuttal on that, Your Honor.
Okay,
In regards to this issue under the People versus Parker case, I think People versus Parker is not only directly on point, it couldn't be clearer. One thing to dispute brother counsel saying that the only evidence was in that case was the description that it was hand size. It's not strictly true, Your Honor. The jury actually went back with the knife. In People versus Parker, they physically had the knife in question. So they were able to look at and examine and make their best guesstimate, but they weren't given a ruler. And it would have been improper if they had been, candidly, Your Honor, to make that measurement. When the law puts out a very specific threshold that must be met, it is the burden of the prosecution to prove beyond a reasonable doubt that that measurement has been met. If we're talking about almost any other type of measurement that we use in criminal law, never would we have even reached this point where that argument could be raised. For example, if somebody was intoxicated and there, as we know, 0.08 is the legal driving limit, the jury would never be permitted to take an officer's testimony that said, oh yeah, I hit him with the breathalyzer and that's what it came up at. They need the actual results themselves. It's not enough to simply say that's what I tested him at. It's not enough to simply say, I know what a 0.08 versus a 0.07 looks like, and that guy was a 0.08. And if we look at other forms of measurement, it just continues to grow more and more absurd. If, possession of a controlled substance over 25 grams, we're not going to go tell the jury, look at this pile of crystal meth, that's 25 grams, yes or no? We all know what 25 grams weighs. Wouldn't measure that in your hand. But we are not in the business of empowering juries to make their own measurements when we do not give them the tools nor the actual evidence itself. The reliance on the body cam footage, Your Honor, those are fisheye lenses. Those distort all the time. We cannot rely on that. And to the extent that we even could, there's not a moment in time where the knife is still long enough to put it against any other objects to try and, well, okay, I know that a standard car mirror is X number of inches and this was about this. So there's nothing there for the jury to have actually used. So I believe it's completely insufficient evidence and it fails to prove beyond a reasonable doubt that element of the crime. And I believe that the People versus Parker case, which is the state analog, is completely on point. And it mandates that that charge be dismissed. Thank you, Your Honor.
thank you. Okay, I'm ready to hear you. And I've heard both of your arguments. I think you make both have great positions. I've already made it clear that I agree that the controlling authority as it relates to the procedure or rule that should have been used in this particular case is 2.516. The court rules are pretty clear. It gives a list of, what a jury or criminal rules that a procedure would apply. And my interpretation is that a 2.516 applies in this particular case. Now, whether I were to use that rule or to apply rule 6.419, I think I still would have come to the same conclusion. And that is that at the time that the court makes, or if I reserve my ruling, which I did, that I need to now consider your evidence that was brought in at that time and not just the people's evidence that was brought in at that time. And so we do have testimony from the officer who testified that the knife was what he believed approximately 6 inches. And then we had testimony later from your witness who wasn't sure that it was above 3 inches, but I think the testimony was that it was a steak knife.
Kitchen knife.
A kitchen knife.
Yes, sir.
Someone described it as a steak knife. I saw the video evidence that was presented, just like the jury saw the video evidence that was presented. Would I be able to look at the video evidence and say how long something is? No. However, I appreciated the argument that was made by the people in their brief about how on an everyday basis, people interact with things that are longer than 3 inches. A Post-it note. I'm sure they're talking about the standard size, not this size, or not this size. It's longer than 3 inches. Our debit cards and credit cards, longer than 3 inches. And so the rule here was only that it needed to be longer than 3 inches. If it was a steak knife, then that was, I guess, up toward the jury to determine if it was or not. Steak knives have to, or it's by standard, over 4 inches. But that was for the, I don't know what their backgrounds were as it relates to determining what kind of knife it was. What I know is that I did have a testimony under oath that this was approximately 6 inches. We didn't have a ruler. I don't know why they didn't bother to measure it. We know that typically, procedurally, they could have measured, and that would have made their case stronger. But I don't think that it makes their case not fit for a jury to determine. It makes a question of fact, whether or not it was above 3 inches. And if the testimony is that it was approximately 6 inches, it's up to the jury to decide if they find that testimony credible. It's not for me now to come in and now discount what the determination of that jury was. And I think the statements and the arguments you made were really plausible. They were great arguments. And had you made those arguments during your closing argument, maybe we wouldn't be here. I don't know. But I can't now go and reverse a jury's decision. I think that it was enough evidence to go to a jury at this point. Even though I personally would have preferred to see them measure it, I think his testimony, based on his experience, that this was above 6 inches was sufficient enough to bring it to the jury to determine the credibility of that testimony and decide whether or not this knife falls within the violation of a knife above 3 inches. If it's approximately 6 inches, it's above 3 inches. So with that being said, the motion for directed verdict is denied. I mean, I think we were supposed to sentence her today as well.
I wasn't sure, Your Honor, whether you wanted to, I had asked for a sentencing date, and I think you said, quote, I'm not going to decide.
I'm not, that's it, yeah.
I would
it's-
move for immediate sentencing. Given
It's
the
a
date.
knife over 3 inches. Your fine is $75. When will you pay?
As soon as possible.
Today?
I can't pay it today.
Okay, well, that's as soon as possible.
I haven't got
Yeah.
those millions yet.
You told, no, you told, I saw it on the, do I know you? Do I know you, sir?
No.
Oh, I didn't know I was talking to you. I wasn't talking to you though.
I'm sorry, but.
So don't blurt out on my record. She and I, she's been here multiple times. We don't have those issues here. Okay,
Sorry.
ma'am, you're famous and you're rich. It was all over the body cam. So I know.
As soon as possible.
And there was a fight over you depositing a check and somebody stealing it, so you're getting money. So when is as soon as possible?
As soon as possible.
Like one day, 2 days, 30 days?
Can you give me 30 days?
I can give you 30 days.
30 days. $75.
If you need an extension, it's your responsibility to come to the court and request that extension, okay? Thank you, and you're all set.
Thank you very much, Your Honor.
Thank you.
Your Honor. Your Honor, while we're off the record, on the Craig matter with Mr. I believe Mr. Jeffries, did you issue anything on that? There was supposed to be the substitution with Warren.
Oh,
I don't know
I
if you-
issued a bench warrant,
Did you?
correct, because she was not here. Is she here?
I don't believe she's here. I
Oh,
just didn't know if you were
okay.
holding it.
No, Michelle Craig? No,
Michelle
she's not here.
Oh, never.
With Jeffries.
Yeah, no, I haven't been able to touch base with her, and I don't think the team has
Who
either.
from this morning you talking about?
Ms. Wilson,
Is she supposed to be logging in?
I thought she was going to at one.
There's somebody here on a Motorola we can see, and then I also have Miss Johnson. I had to put her in the waiting room because she was taking it out. Who's
My
representing Miss
apologies.
Johnson? Who represents Miss Johnson?
That's me, Your Honor.
Are you ready on her matter?
I think we are ready.
Okay, City of Lansing versus Nikita Johnson, 25L29422072, and 71. Appearance, please.
Caption on behalf of the city of Lansing, Your Honor.
Jacob Riley on behalf of Ms. Johnson, who's appearing by Zoom.
Oh, and 73. There's 3 files. I have a speeding over 16 over, open intox driver, and a no proof of registration. How are we proceeding today?
I will be requesting adjournment so that Ms. Johnson can complete a victim impact panel at the request of the city. In furtherance of negotiating resolution to particularly open impact, but really the entire situation.
Okay, so no offer until she's done that. Is that correct, Mr. Wu?
Yeah, that is fair representation. There's also some other pending, there's a probate matter related to the vehicle that she was driving that is pending still, and we're waiting for that to resolve on the registration front.
Oh, so how much time are we looking?
I wish I could tell you I knew when the probate matter will be settled. I think there's her mother's vehicle. Her mother passed away in February. It's been 5 months and it's still not resolved.
Okay, so the registration, got it. That's for the registration issues.
Correct.
Well, we sure enough can't wait for probate court on that. So we'll just reset it to see about this victim impact. Okay,
We're
hopefully
hopeful on a
probate will
resolution.
move, but
Yeah,
who knows what's going on.
I'm not gonna go yet.
August 26th at 10:30.
August 26th at, you said 10:30? At 10:30 is your next court date, okay?
Okay.
Wait, who's on a Motorola smoking a cigarette in my courtroom? With a do-rag or a stocking cap on their head. This is court. What's your name? You're muted.
Okay,
What's your
you hear
name?
me? Calvin
can hear you.
Randolph. Calvin Randolph. Can you hear me?
I can hear you. You need to put the cigarette out, and you gotta treat this just like you would treat it if you were sitting in my courtroom. Otherwise, you'll be sitting in my courtroom.
Okay, I don't have the other person putting the cigarette out. Cigarette's out.
Thank you. Okay, Ms. Johnson, do you have any questions for the court?
No.
Okay, we'll see you August
No, no, it's
26th
okay. Okay,
at 10:30.
okay, thank you.
You're welcome. Thank you.
Thank you.
Was that all the city stuff? Is that what's going on here?
There was the file you held from this morning.
Wilson?
Yes.
Okay, I'll issue a bench warrant. She's not appeared.
Yeah, I talked to her twice today. I don't know why.
You can only try.
Thank you, Your Honor.
Thank you.
Have a good rest of your day.
Thank you. Okay, let's see. Who's here for Smith?
He met with Anderson and then every,
Oh, Mr. Smith is here. He met with Anderson.
but I don't know if they're in person with the rest of his discovery. I think.
Do I have those files? Are those like paper files or what you call it? On base. There it goes on my.
I'm assuming it's on base. You don't have any files?
Why do you think I don't have any files?
Are they on?
They on base? I don't know. Mr. Smith, did you meet with Mr. Anderson? Are you satisfied?
Yeah, we did, Your Honor. He's going to have this judgment paid in full in the next 30 days. I'll get in writing to him confirming where to send the money. Then we'll get a satisfaction of judgment filed at that time. I want to thank Mr. Anderson for his help today.
Okay, so you don't need another date.
No, ma'am.
Okay, Mr. Anderson, you're all set. Thank you.
I had 2 other matters at 2.
Let me just note this one. Robert Lippincott present. Oh, it wasn't here, Dr. Did we just go to bench? Is that what happened? Yeah. Okay. Okay, Mr. Lippincott is not here. How do you want to proceed?
File a motion to show cause, Your Honor. We'd like to serve it by mail. He was personally served at the Elm Street address. We'll serve the order, show cause order to that address.
Okay, that will be granted. If you can upload that to my file, I'll review it.
All right, we'll get on that, Your Honor.
Thank you. And let's see. Is Johnny James present?
Courtroom 4.
Is that a physical file? I didn't see that. How do you want to proceed on that one?
He was personally served at the West Jolly Road address. We'd like to file a motion to show cause service via mail to that same West Jolly Road address where he was personally served.
Okay, that'll be granted. Thank you. And
Thank you, Your
then you
Honor.
have one more.
Those are the only three I had. What was the last name of the case you just asked about?
That was James, Johnny James, but I also have, was this all set, Toribio?
That was canceled.
That was canceled. Okay, very good. Thank you.
Okay, thank you, Judge.
No problem. Let's see, Case Credit Union versus DeAndre Carter.
Good morning, Your Honor, or good afternoon, Your Honor. Scott Chernich on behalf of Case Credit Union.
I don't know these files. Are these like physical files? They have to be, the ones in on base are engaged. I don't have what I've served on why, because I think she went probably down to silver to grab. No, you're lying because I was out all last week. There's no reason why my cases are not ready to go. Off the record.
Yeah. I didn't get you one of them time. They free.
I'll wait till last minute. Didn't have time. Guys came up on me. Hello?
Hello? Hello?
Okay, so I just, it is, Carter. Which one? I thought it was Andrew Carter. No? That's an 11 file. That's on here. Did I do that one already? What you call the one that wasn't on base? This isn't on base. Okay, no one's here on behalf of DeAndre Carter.
Nobody's checked in with me.
Counsel, how do you want to proceed?
We'll file a show cause motion.
Okay, show cause to issue. You can file that on base.
I'm sorry, say that again.
You can file that, upload that to on base.
Oh, sure. Yep. Thank you.
Thank you. Thank you. Kathy Schasberger versus Melissa Coleman, 23-02760 LT.
Good afternoon, Your Honor. Nicholas Garlinghouse appearing on behalf of Ms. Schasberger.
What's your name?
Melissa Coleman.
Your name?
I'm Hunter Walker with your recovery coach with Ministry of Recovery Services. Just working on housing.
I'm sorry, you're just doing what?
Working on housing with me.
Okay, I'm trying to understand. This is my first time seeing this file, so obviously I've not seen the motion. This is a motion to, what is it, to consolidate? Let's see, motion dismissal of eviction. I was never evicted from 3120 Sublime Parkway Drive in Lansing. This property is my mother-in-law's home that I shared with my husband. I left the home in January. I've been living with my husband for the past year at our home until our lease ran out May 17, 2025. We are currently going through a divorce and he is residing in the home. We filed that motion and then I have a response. Okay, so there was a consent order of conditional dismissal that was filed in this previously.
Correct. And I was out of the house on the 31st of January. Not residing in the home. My husband was residing in the home. He had a no contact order with me because he was facing felony domestic abuse charges. So his mother, that was our marital home that we shared, and Kathy owned the home. So she tried to evict me so he could live there without.
Correct. You ended up, you're saying you ended up leaving.
Yes. And staying with my mother. And then me and Dustin moved out of that house together. Like, well, he moved out and I moved in to Briarcliff Townhome Apartments on May 16th, 2024. And we had a year lease contract for a whole year and it just ran up May 2025. And now I am trying to seek housing and I found out that there's an eviction on my record from his mother. I'm trying to find stable housing for me and our daughter, her grandchild.
Okay, it looks like the last piece of mail that was sent even to her before the 30th or the 31st or the 24th was returned undeliverable.
Right.
Yeah, I don't have a record of that, Your Honor, of anything being returned.
It's in my file. The court sent a copy of the paperwork on the 26th of January 2024. It came back undeliverable. She was not at that address.
Okay, and then, yes, Your Honor, in February, it was actually on the 5th of February, we filed the affidavit of non-compliance in order to get the writ of eviction because she had still not removed her items from at least all of her items from the house and had not turned over keys. So we had moved forward with the writ at that time.
Let me see here.
I couldn't move any of my property out of the home because it was our marital home and we were going through divorce and there was no way I could move out our marital property out of the home. So I just took my clothes.
That
And there was
sounds
a no
valid. She
contact
lived
order.
there with the husband. There's a no contact order. She can't remove personal property. So what items are you saying that she left there?
Your Honor, I'm not sure what all the items were. I know there was some furniture and some just household items that were still there. And my client wanted to change the locks, but I told her that until, we had gone through the entire process, she should not do so to avoid any sort of claim of wrongful, self-help or unlawful eviction.
Okay, well, your client needs to come here and tell me what items she left in there because she said she took all of her items and you were living someplace else.
I lived at my mother's. I was staying on her couch.
Okay.
And Kathy Schesberger took me to treatment. I was in treatment from January 19th to I got discharged on the 31st, the day I was supposed to be out of the home. And she took me knowing that I wasn't. And then she just evicted me the next day, like legally, I guess. I have like.
And it was your understanding that her son, your husband?
My husband, he was in a different treatment center at the time.
But that he was still living there?
He was going back to live there, yes.
Okay. Now, is this the husband that you've been living with for the last year?
Yes,
Okay.
and we just, now we're going through another divorce.
Okay, so you were attempting to
Reconcile.
rekindle. Okay, sounds like a mess
It's such a
we have
mess.
on our hands. And I'm assuming there was no other, there was no eviction for your husband, it was just
No,
for you?
Just for me.
Okay,
And I never signed a lease or anything. I was never on a land, I never signed anything for her even to just evict me.
well, you don't have to sign a lease. If you're possessing the property, they have to do a lawful eviction. However, to your argument is that there was more than one occupant that you lived there with
My husband and
with
my
her
child.
husband, which is this is his mom's home.
Yeah.
There was a no contact order at the time. You vacated, you said according to what your agreement was, but then later you were held responsible for what we believe may have been some personal property in there, but we're not clear what that personal property was.
I left all of my couches, my dining room table, my tea, everything was still in the home because Dustin was living there. It was our marital home. I hadn't lived anywhere else for 6 years.
But you took all of your personal
My
things that were just
clothing,
yours.
shampoo,
You're saying you just left the furniture because
Yeah.
you jointly own that.
Yes, and I just had filed for divorce in September, so we were going through, we had marital property together and we hadn't even gone to our first court hearing.
Okay, Mr. Garlinghouse, you don't even know what items were left.
No, Your Honor, other than that it was some furniture and, household items. And that the keys had not been turned over.
Well, not turning over the keys doesn't give you the right to evict somebody. Put an eviction on their record for a conditional dismissal, especially under these circumstances. And I think that that's a bit of a stretch. If she had actually left things there, that's different. But I think that the documents that's been filed, including the counterclaim, make it clear that she was living there with her spouse, who was obviously your client's child. And stated that she had already been constructively evicted from the house in the first place. Granting her motion. Because I don't believe that the affidavit was accurate. I think it contained some misrepresentations. So based on the material misrepresentations, I'm going to set aside the eviction on your record. And I'll enter an order stating as such. Any additional matters for the record?
Nothing for me, Your Honor.
You're all set.
Thank you. Have a good day.
Correct.
But there'll be an order issued, and can I have an address to send the order to?
Yes, 143 Lake Ridge Drive, Mason, Michigan, 48854.
48854,
54, yes.
54, okay. You're all set.
Thank
Thank you so much, Your Honor.
On which matter? Mr. Gromer is here on which matter?
Good afternoon, Your Honor. I'm here on Riverfront Apartments and William Vanderbest. It's 02255, Judge.
Is Vanderbest here?
Oh, Your Honor, just as a recap, this was just a technical correction to the caption to make it the estate of. You requested a written motion.
Oh, okay, let's see here.
And then it was set before, and I think we're in the middle of a trial in June, so it got pushed again. I know I popped into the middle of a trial. That's my notes.
Let's see, motion. Name. Motion to amend summons and complaint to correct party name. To the state. Was there an order?
I could submit an order, Your Honor, but the request of it.
Yeah, if you had to file the order originally, I would have just signed it.
Yeah.
So you can submit the order, your motion is granted.
Your Honor, and then obviously we're requesting a default judgment under that order.
Default can enter, and you can submit orders for both.
Okay, thank you.
Thank you.
I know you gotta be kidding me.
Who gotta be kidding you?
Oh, I'm sorry. I thought that the court was over.
I don't see nobody on here.
What is happening? You fix your screen so that you know that you're not the only person in the courtroom. You gotta scroll over. Okay, this is Manor Born LDHA versus Lakia Hester, 25-02762, council appearance.
Thank you, Judge. Good. Joe Joseph on behalf of the plaintiff.
Lakia Hester is present via Zoom. Let's see. You don't have an attorney representing you, is that correct?
Yeah, so I spoke with one after our first court date, and they didn't really help me with anything. I explained everything to them, and they didn't help me with anything. Also, I apologize for saying you gotta be kidding me. I thought the court was over before I talked to you.
No, so I do see that you met with legal services, but that doesn't mean that they can take your case. They have to do an intake to see if you're eligible, and for some reason you must not have been eligible, and or they may not have had the capacity to take any additional cases because they are limited. However, after that, you were at that court date, you were provided a date for a hearing, and that's the hearing you failed to appear at.
Yes. So I had a funeral that same day. My cousin had just passed away. So I actually had forgot about it. And then once I had tried to hurry up and call, I thought it was on the 3rd, but it was actually on the 2nd. So I tried to hurry up and call, and then that's when I went up there and I tried to, reschedule a court date.
Okay, I'm reading your motion. It says records state that you haven't paid since 2021, but you missed court due to a funeral, and you have money orders or receipts to demonstrate that you paid. You disagree with the judgment due to lost files from Pinebrook Manor. They lost your recertification packet and caused your rent to go full market. You explained that to the regional manager and also current, I'm assuming you're saying the current manager.
Yeah.
They still insist that you owe an outstanding amount. Also, this is not the first incident where this has happened. Counsel, did you want to respond to her motion?
Well, yeah, Judge, she's not at market rate. There was one point in time where there was a failure for recertification, and it did go to market rate. I believe that's been rectified, but that was a while back. I have my client here who can testify to that probably more specifically than I can, based on the records that they keep. She has made, I'm not sure exactly where she's referencing someone saying she hasn't made payment. There have been several credits made on the account in her ledger. So we do recognize that payments have been made. It's been a while since payments have been made. But in terms of the balance, there should be no dispute as to what's currently due. I have the balance that's currently due, which is $12.23, but I believe at the time of judgment, that is accurate. The $12.23 is accurate, and plus the court costs of $182.04, which aren't in her ledger, but that's what we show, and that I believe that is accurate. And like I said, my client's here who can testify to that effect as well.
Okay, well, we're not here to receive testimony as to the actual facts. We're here to determine if there's good cause to set aside a default and meritorious defense. Her good cause would be that she was at a funeral, she mixed up the court dates, and then she did report immediately to try to change it. The defense that she's asserting would be, as I understand her motion, is that she disputes the amount, that she thinks that there's an error, and that this is not the first time it happened, and that the allegation is that she's failed to pay rent since 2021. I'm looking at the complaint. It does say rent is paid through February 28th, 2021. Her motion to set aside default is granted, as I found good cause and a meritorious defense.
Thank you, Judge. So
this will be set for a hearing.
Thank you. Date and time?
You do August 13th at 1:30.
August 13th at 1:30, in person at the court. Okay, ma'am?
Yes, ma'am.
Judge, given the delay, are we able to do an escrow order since that's about a month away?
And you absolutely can file for escrow of the rent.
I'm sorry, I missed it. It cut out, Judge.
Yep, you can file a motion for escrow through my file and I'll review it.
Okay. Thank you.
Also, Your
Yeah.
Honor,
Yes.
so I still took the proper steps as far as, I'm okay with the court hearing because I stand on what I say, but I did go through the proper steps for the 311. So I actually have that in the play as well. I just feel like I'm having to get assistance for something I do not owe. Like again, they don't keep managers, so they misplace files, and the tenants get held responsible because they can't keep managers.
Okay, so what you'll do is on the 13th, you'll make sure you compile all of your records, and you'll bring those to court with you, and then Mr. Joseph or a representative from his law firm will bring their records and witness, and then you all can have time to discuss it, and maybe you'll come to a resolution that they were right and you were wrong, or maybe you'll come to a resolution that you were right, they were wrong. But we can't do that via Zoom today. You all need to come in person with they'll bring an accurate or up-to-date ledger. You'll bring your records and then you'll have an opportunity to cross-reference it. If you can't come to a resolution, then I'll make a decision at the time of the hearing, okay?
Yes, also one more question. So let's just say if 311 pays it before August 13th, if I still want to come to the court date, what will happen? Does it get credited back, or like I'm confused?
Well, if they pay the balance in full, then the plaintiff can dismiss the case. But if you're saying that your rent is not accurate, then you definitely want to meet with them and see if you can get on the same page about what it's supposed to be going forward so that you don't end up back here.
Yeah.
Mr. Joseph, you were going to say something?
Yeah, I was going to say, obviously, if she pays it to a zero balance, we'll dismiss the case for sure. But I would like, since I think it's present from the property, I think it would be beneficial if Ms. Hester and the property manager can speak so that they can clarify the issues. I do tend to agree with the court about the good cause and obviously her allegations, so they're being meritorious defense. So I think it's appropriate to set it for a hearing, but I think it'd be advantageous if the parties can speak between now and then, try to resolve the discrepancy. And I think the discrepancy comes from a line item from back in May of last year, 2024.
Sounds good. If Ms. Hester would like, I can put you all in a private meeting room now to discuss it, but that's up to you all.
I'm open to that if everyone else.
That's fine.
Okay, let me get you in a room now.
Thank you.
Okay, and this is probably the last one. LVNV funding versus Calvin Randolph as 25-00884 council appearance.
Good afternoon, Your Honor. Navjot Francis on behalf of Plaintiff's Attorney of Record.
Okay, and then Mr. Randolph is present via Zoom. Let's see here. This was the date and time set for pretrial. Did you all do a joint pretrial statement yet, or do you need to do that now?
No, I'm sorry. I wasn't aware he was on Zoom, so we did not go in a breakout room yet.
Okay, it looks like he filed an answer to, so okay, let me get you in a private meeting room.
Thank you.
No problem.
Dismissal. Back to the courtroom.
Ms. Francis,
Yes, Judge.
this is her judicial assistant, but did you
Oh,
guys work
okay.
out a resolution or did you fill out the joint pretrial statement?
We worked out a resolution. He's given us
Okay.
permission to sign the consent judgment so we can e-file it.
Okay, I'll just wait for Judge to come back so that we can place the terms in the record.
Okay, sorry, it's hard to see over there. It's like very small.
It's okay.
Is it okay if I run to the restroom real quick?
Yes, that's fine.
Thank you. I'll put my video back on as soon as I'm back.
You see a hair on
Mm-mm.
you? You ain't even.
I can't say anything, sorry.
That was the longest Zoom court meeting in my life. Yeah, no.
I am back whenever the court is ready. And I appreciate the break.
Okay, counsel, my understanding is that you all have a resolution.
Yes, Judge, we do. We
You
have,
can put it on the record, please.
we have agreed to a consent judgment. The amounts are damages of $786.94, costs of $96.50, plus the $75 statutory attorney fee for a total of $958.44. And we have agreed to a monthly payment plan of $35 per month, starting August 10th and by the 10th thereafter, and defendant is giving plaintiff permission to sign the consent judgment so we can submit it to the court.
Okay, Mr. Randolph, is that complete and accurate as to how you want to proceed? I couldn't hear your response. Is he muted? You're muted, I believe.
Hello?
Yes,
Can you hear me now?
I can hear you. Is that how you want to proceed on this matter?
Yes.
Okay, you understand that you did have the right to proceed to a trial. You could have demanded a jury trial. You understood that, right?
No, but it's all good.
Okay, no one's threatening you to enter into this agreement.
No,
Okay, do you have any questions for the court at this time?
no, I don't.
Okay, let's see. Did you file a counterclaim?
I'm not sure what you mean by that. When it first came to me, they said the amount of time that I had, but it wasn't. Only like a week before I had supposed to sign up the first time. Then I redid this for 3 days within another day.
Okay, I was reviewing the file. It said counterclaim, but I think they just are referring to the answer. So this will resolve the matter. Counsel, you can upload that into my file. I will review and sign it, and that will take care of today. Thank you, sir. Thank you, ma'am.
Thank you, Your Honor.
Have a good one.
You too.
We don't have anyone else in the breakout room, do we? No.